Today's presentation is part one of a two-part series for which each session must be registered separately. The second session is 2 weeks from today on August 29th. Both sessions will be recorded, so if you can't make the second session, if you will just contact us at Austin Mediators Association at gmail.com. We'll make sure you get the link so that you can see the session at your leisure. For those of you who've registered for CLE credit, I'm going to wait until after the second program on August 29th to report your attendance to the bar so that I can accurately report either 1 or 2 hours credit, including 1 or 2 hours of ethics. We have 19 attendees today who are not members of Austin Mediators. I'd like to welcome you. We meet every other month with an educational presentation at each meeting. 2 of the meetings are in person at the Austin DRC, and the others are on Zoom, like this one. John has let us know that he is very happy to answer any questions. You can either put your question into the chat or raise your hand and we'll call on you when there's a break. And I believe that's all the housekeeping matters. John is a trial attorney, mediator, and arbitrator with Naaman, Howell, Smith, and Lee. John serves as a mediator and neutral in probate, family, general civil litigation, personal injury, and employer-employee disputes at the state and federal court level. He received his undergrad degree from the University of Texas and his JD from St. Mary's University School of Law. In 2002, John was an ADR fellow with University of Texas School of Law Center for Public Policy Dispute Resolution. John is currently chair of TMCA, past chair of the ADR Section of the State Bar of Texas, and past president of Texas Association of Mediators. He's a TMCA credentialed distinguished mediator. John was a founder of the McLennan County Dispute Resolution Center in Waco 20 years ago and remains on its board of directors. In 2001, he received the Justice Frank G. Evans Award from the ADR section of the State Bar. He received the Suzanne C. Adams Award from TAM in 2017, the Outstanding Mentor Award 2018 to 2019 from Texas Young Lawyers Association, and the Outstanding Credentialed Mediator Award from TMCA in 2020. In addition, John and Robert Prather are co-authors of the Texas Practice Guide Alternative Dispute Resolution from 2019 to the present time. We are so honored you're here with us today, John. Thank you for coming, and the stage is yours.
Well, thank you, Linda. And I've known Linda from way, way, way back. And you know, this silver hair we have, Linda, is just a front. We're really young at heart, right?
Right.
So,
got it.
All right. So thank you for having me here today. We have a lot of folks, which is exciting. And as was said, I want interaction with this. It needs to be interactive. I want to hear people's responses because I can tell you I don't have all the answers. And if you think that, then you're on the wrong channel here today. Go watch something else. So we're going to start with the premise. There's a few premises. One is that we're talking mainly family law, but if we want to talk about other mediation sources, that's fine. But a lot of the things in my PowerPoint will eventually, either today or 2 weeks from now, talk about resources you can use to help you in the family law mediation. The second thing is I am assuming for our discussion that we are having all pro se parties. it is the dynamic when there is pro se and versus a party who has an attorney is completely different when mediating. And I'm happy to talk about that as well, because I mediate differently when I've got a lawyer with a party versus and then a pro se. And because most of the time I will do that caucus style or meeting in different rooms. And so the way I'm talking to a party and their attorney is a lot different than when I'm talking to a pro se. But in this scenario, I'm thinking primarily about that. But if we want to open this up and talk about why do you do it differently, or what you think, then I will be super happy to talk about that, because I need to talk about that if you have questions about it or what your experiences are. There are a lot of people I recognize here, a lot of people I don't. But I want to see and hear y'all's responses and your thoughts, because I think that only enriches our group and doesn't detract from it. So I've got up on the screen, it should say ethical challenges with pro se parties. Is everybody seeing that? Yes. And so, oops, it shouldn't have done that though. Not sure why it did that actually. That's good. Okay, there we go. Back to that. Does it say ethical challenges with pro se parties? Yes. Yes. Okay. Thanks. And so I have some boxes here, but I think we need to think about, who we're dealing with. And the first box is really one in which, of course, but in every case, a majority of the parties in a family law case have never been in a family law case, have no experience in a family law case, and they don't even know what a mediation is. And so our job as mediators is to manage expectations. The next box that I think that is of when we think about doing all this is parties deserve to understand the mediation process and your role in their dispute. And then we have to keep thinking about, well, what does a pro se think? They have preconceived notions about how this works in the law. And we need to be prepared to talk about that in a non-legal manner. Some of you are attorneys, some of you are not. The temptation as an attorney is incredibly vast and large to give someone advice or to talk more legally towards them at all times. But folks who have mediated a lot of family law cases know things that are just secondhand to them. Oh, well, here, let's talk about rights and duties. And this is what, blah, blah. Well, okay, hold on. They're not going to know what rights and duties are. Linda and I had this very short conversation before we got onto the main group. And we talked about, well, we make all these type of assumptions, but they will say, okay, well, we'll just agree that we will cooperate in parenting. They will write that and they'll say that and go, yeah, that's our first agreement. Well, they just wrote that and then tried to give it to a judge is going to look at them like, no, well, what about who determines domicile? Who has the right to make medical decisions? How did you decide all that? And they're going to look at the judge like, don't know. And so, we have to be very intentional, but careful about how we talk to our pro se parties. And so parties inevitably ask in agreements, is this what the judge would do? Or is this fair? And y'all have all witnessed and experienced is this fair question? Or maybe the other way to say it is, this doesn't seem fair to me. Do you think it's fair, John? And the answer, and we need to think about that. And we need to be prepared to address this question. And the other questions like, hey, if you were in my shoes, what would you do? And, there are certainly good ways to address that. And then, of course, when we get towards the end of this, and we're not going to be talking about this today, is, to draft or draft. That is the question. And I see a lot of faces who are very familiar with this topic, but it's always good to talk about it. And so we will have those ethical challenges along the way. So as everything that we think about when we go and approach a problem is we have to have a good foundation. If you don't have a good foundation, what happens? The house falls. And so we need to think about how we approach all these problems and what is our guidelines for this. So the only promulgated guidelines that are out that are sanctioned by the Texas Supreme Court is the ethical guidelines for mediators, which were initially promulgated by the ADR Section of the State Bar of Texas, and then the Supreme Court in three miscellaneous dockets updated those, and those are easily available if you type that number. And so we look there. The crown says, no, these are not mandatory, but then I write, they are the standard. Because if you look at case law, the courts look at what the ethical guidelines are. And so while they're not mandatory, they're guidance. And when a court is looking at these, they're looking at what the Supreme Court has promulgated and put in their miscellaneous docket. So very important to keep that in your mind as you go look at these, that while they're not mandatory, you're going to be put to that standard at the very least if someone is going to sue you, in other words. And then I would suggest, since I'm certainly chair of the TMCA, that you might want to look at how it would look if it's a mandatory type of ethical guideline and not a guideline anymore. Look at our website at txmca.org, because what we've done is we've basically said, if you want to be a Texas credentialed mediator by the TMCA, then you are going to be under a shall kind of mandatory versus, a type of, hey, these are guidelines. So very important to think about as we go through this today about ethics and the standards of those. And so we'll start with our basis, the foundation, and the guidelines at the top of the list. So, mediation is defined as a process in which we as mediators encourage and facilitate communication with the goal of the responsibility for resolution of a dispute. But the primary responsibility for the resolution of the dispute rests with the parties. We get to make suggestions, but those decisions are made voluntarily by the parties. And then we talk about things. So this is going back to, and those who've heard me talk in different areas, I go back to, when do we talk about all these things to the parties? Now, I have the luxury of what I do with all parties, whether they're pro se's or not, is if they're represented by attorneys, I just grab the attorneys, but I do pre-mediation conferences. I have a pro se mediation with all pro se parties coming up on Tuesday. I brought all of them in the room last week and went over the ethical guidelines for mediators and the rules that I have for mediation. And the reason I did that was, one, for them to hear the same thing, but two, for them to really appreciate the process that we're going through. Now, people don't necessarily have that luxury at times. It takes time. I mean, I spent 45 minutes with the folks going over my ethical guidelines that I had pre-sent them in an email and said, these are the rules we're going to go by. We're doing it by Zoom. So I sent in the Zoom guidelines and I talked to them about confidentiality. And so the mediation process, under the guideline at the top of the list is, at a minimum, the mediator should inform the parties of the following. Now, a lot of mediators say, well, I put it in the letter, so they're informed of it. I think especially with pro se folks, well, lawyers don't read things they're sent, period. But the parties themselves, pro se's especially, may not have read this, and they certainly probably don't understand it to the level that we understand it. So I sent it to them in writing, but when I met with these folks last week, I went over and said, this is a private meeting. It's confidential. You can't record it. And then also what I talked about is that the other part of this is, because there's a cost for the mediation I'm doing next week, I said, this is the cost and this is the hourly rate. because those are the types of things under, for example, under paragraph 3, paragraph 3 that we've got to talk about. I cannot click on this and make it stay. So on paragraph 3, that would be something communicated. So as soon as practical, we're supposed to talk about cost. Well, you put it in your letter, but then you also talk about it, and I talk about it in my pre-mediation conference. And so that is very important. And then I also talked a little bit about myself. And so I do all that in the pre-mediation conference to set the foundation for expectations. And then also with pro se's, I certainly talk about the fact that we're going to be talking about things that have legal ramifications. I really think you need to think about having a lawyer with you at some point. Maybe we talk at this and then you look at it and think about it and then take it to a lawyer. But I certainly am very clear that I am not their lawyer, and that is certainly something I tell them that I am, but I'm also having them sign an acknowledgement that I am not their lawyer. And I have in the materials on page later back in the near the back end, I have a little on page 14. So I'll just pop over there. I also send them a pro se acknowledgement and agreement. And it's fairly simple, but it certifies that the party in the mediation, which is being mediated by me, has been notified by me that I'm not, that they have elected to be represented by legal counsel, and they've notified me that it's in the best. Then I've notified them it's in their best interest that they think they be represented by counsel, and that that I don't represent a party and will not render any legal opinion or advice. I make it extremely clear. And then again, I talk about them being responsible for reading the rules for mediation and being bound by them, and that they certify that they are bound by the rules and knowingly decline to seek advice of legal counsel before agreeing to abide by said rules. And so I go over that for the purpose of talking to them and making sure they understand where we are in this. And so it's very important to have that type of foundation. Ethically, for pro se's, we have several rules that certainly under the guidelines, either the ethical guidelines for mediators or by the mandatory standards of ethics in other organizations have. So Rule 7, we should not convene a mediation if we have a reason to believe that the pro se party fails to understand the mediator's not providing legal representation for the pro se party. So as you saw in that acknowledgement, that's exactly what we're trying to do. So if they still don't understand that, we have an ethical obligation to say, maybe we shouldn't do this. And yes, I may be out of a fee, but I'm doing something that is in the best interest of me and that person not to do it. And so we've always got to be thinking about the party. And so as it relates to Rule 7, it says we should also look at rules. We need to look at rules 9, 10, 9, 11, and 13. So we go to Rule 9. We should be impartial towards all parties. Well, okay, that's simple. But then there's a comment that says, if a mediator of the parties finds that the mediator's impartiality has been compromised, the mediator should offer to withdraw. And then it talks about favoritism and things like that. But making sure that we are impartial towards people who are either represented one side versus not represented. And I told you I was doing a major assumption of this being someone who's not represented both sides, then it should be very clear. But you've got to be very careful because there may be someone who's has done more research when you're talking to them, and you need to make sure that you go, I hear that I hear that. I understand that you've done more research. Why don't we share it? Because what I do that is highly different than what I do in my mediations when I have both attorneys present with their parties, or is that I usually, when I'm doing pro se's, I like to have them in the same room. I want everyone to hear the same thing. I want them to feel like they are, if they want to share something, then I want to try to, I think it's easier almost to manage everyone's understanding of what we're talking about. Um, Now, of course, you can't do that if there's family violence. You can't do that if one person feels uncomfortable or there's a great imbalance of power. You have to test all those things, right? Um, and so that's rule 9. So we've got to think about that. And then we need to think about rule 11, which is a big one about a mediator should not give legal or professional advice to the parties. Very hard. And so, again, we have to, and under the comment, we have to encourage the parties to seek legal, financial, tax, or other professional advice before, during, or after the mediation. And then we have this comment B, a mediator should explain generally to the pro se parties that there may be risk in proceeding without independent counsel or other professional advisors. So there's all that is a part of our ethical guidelines as mediators to do. So we need to make sure we do that. So hold on, I've got to maybe turn on this on do not disturb. And so so think about that. So I'm going to take a breath and I'm going to ask the audience whether or not how they communicate in advance to the parties other than in writing. Is there anything else that people do that you think of that you like, Linda?
Oh, I'm sorry. I wasn't going to ask.
Okay.
I was going to ask you, when you're in a pro se, say for example, a divorce mediation, and you see a very obvious power imbalance, and you you want to tell the party who doesn't have the power, I really think you should think about that more. How can you do that without clearly saying this other party is really taking total advantage of you? How do you, I mean, the only, of course, the extreme thing at that point is to just end the mediation and walk out. But is there a better way to handle that?
Well, I'm going to ask everybody else. Is there a better? That's a great question, Linda. And so, is there a better way to handle that? And I'm going to ask Diane Harvey because I know she has the answer. Diane?
Sorry, I might not. Um, I mean, as I'm thinking about this, I'm thinking about how I say I'm not a therapist either here. So I kind of feel like I have a luxury of of course saying I'm not a lawyer. Everybody knows that.
Right.
But by the way, I'm not going to give you therapy advice either. And I put it in writing before somebody comes into my office. They see it.
So, and I appreciate for those who don't know Diane, which most people do. She is one of the blessed that is not an attorney and doesn't, but she understands attorneys, and she has a son who's an attorney, and so there's all sorts of legalism going on in her brain, but I think it is probably a very big temptation for you, Diane, not to sit there and think, okay, I'm going to start counseling this person because this person has this issue that is causing this to get in the way. So,
Often.
and so how do you, so as a lawyer, I know my temptation is don't say this, but then I'm going, wait, I'm doing it anyhow. How do you stop that temptation?
So somebody asks me, like I even had somebody come point blank and ask me, do I need therapy? And I say, well, everybody could use someone to talk to. You know, I kind of vaguely go around the edges. If I think somebody is not able to participate because of mental health issues, um, And I've usually by then split them up into separate rooms because of that. Uh, I will end the mediation. I did this just a few months ago with a DRC mediation with somebody who was a lawyer. Um, and as things go with therapists and lawyers, I'm much more tolerant of a lot of kind of crazy talk. And he's like, can we end it? Can we end it? Can we end it? So, but I want to hear the whole thing. And yes, in we me and my co-mediator got together. He said, I just can't have them sign anything. And I say, I agree. And we called the mediation. But that was the most extreme case I've ever seen.
Very nice. Anybody else have anything to add? There is a question on the chat about explain or other professional advice. And the problem is that the comment A says legal, so that's one. Financial, that's another person. Tax, that's another person. Or other professional advice. That would be something, for example, let's just say it is a realtor. And someone wants to know the value of a home or value of a business. And if the value of the business or the value of the home is at issue, then that is a big challenge. And you go, well, we could look at the appraisal district if you want to, but if you really are disputing the value of this and you want to have an appraisal, maybe we leave that blank now and we keep talking, or maybe we need to stop and come back. And so that's an example of other professional advice that comes off the top of my head. If somebody needs repairs on a house, or values of a car, or really cars are fairly easy because you can look at the Kelley Blue Book. But when you start talking about farm equipment, there is no Kelley Blue Book for farm equipment. Values of cattle, we have that. Guns and cattle are a very big thing here in Texas, and so. And you can tell that I'm a cowboy. And so, in my cowboy life, I've never owned a cow. I have fed a cow. But other than that, what you do is you give some guidance about where they might be able to look. But most people who are in the business of having a lot of heads of cattle know exactly how to do it. But, the spouse may not. And so that's the bigger challenge. And if the spouse doesn't know, then do they believe their other spouse, or do they need to go do investigation? And so that's what that would mean. That's a good question. Now, Bruce, yours is a little bit longer. Do you want to tell me what you've written? Because I do better than right now than reading that.
Sure. It's basically the case where you're mediating a divorce. Neither party has attorneys. And in one situation, party A says, the Texas divorce law says such and such. And the other party just agrees with that because they don't know. And they go ahead and create an agreement when you know as a mediator that that's not at all the law. And the second case is, the first case says, yeah, you have to pay me spousal support for X amount because that's what Texas law says and the style that I'm accustomed to. And the other party looks at you and the mediator and says, is that true?
That's a great. So how have you handled it, Bruce?
Wow. In the first question, I asked the first party, I said, are you a lawyer? And they said no. And I said, where did you get your source of information? I'm just curious. Well, that's the way it is. I said, could you tell me more about that's the way it is? And it turns out they both had lived in California a long time. And she was kind of referring to alimony. And I said, well, I mediated a lot of divorces and I'm not a lawyer. And this seems unusual to me. In the second in the second case, when they specifically said is this true or not, I say, I'm not a lawyer. I can't give you legal advice. However, if you'd like to take a time out and try to do some of your own research or find some other information, that might be helpful for you. But I really can't tell you what the law is. I basically say I'm not a lawyer, and not only I don't want to interpret it as Walter writes Iraq, but I don't even want to explain it because I don't even have a law degree. So that's how I did it. But I want to hear the experts in the room.
Well, I'm not, someone's raised their hand, but I will tell you that one of the things that I usually bring with me is either this, which that's the Texas Family Code. And so I can say, okay, you're talking about alimony. Here's you can look in the book, but here's chapter 8 that deals with maintenance. Would you like to read this? Because I am not about to give them legal advice. But the nice thing is, and the other nice thing that happens that is almost a miracle now is a lot of lawyers are using this to do their own research now. And that's what people do is, if you're not sure, you need to look at it on your phone. And if you're still not sure, I brought the family code if you'd like to look at it, but I cannot give you legal advice about that. And so I love your approach, Bruce, and I agree with that. I think that generally you go, I've heard this, and I can't sit there and go, well, I'm not sure what the judge is going to do. I can't do that. You have the greatest excuse in the world because you're not one of me. And so at the end of the day, I can't feign ignorant. Well, I can feign ignorance all the time. Catherine Logue would tell me that I'm ignorant a lot. But and so all that being said is that I can't hide behind that shield, but I can certainly say the shield is I've got Rule 11 that says I can't do this, and I have an ethical duty that under my law license I can't do this, and so therefore I can direct you to some resources, but I can't take you there. So that's the way I would do it, and I don't know what anybody else has to say about that. I know Todd Fine's a lawyer, so I think. So
that is correct. I'll agree with that.
There you go. Hi, Todd.
Hey, John.
All right. So anybody else have anything else to add? And then we want to ask Sean the question, or anybody else want to add to that?
I saw Bob's hand first and then Elaine.
Yeah. So I do all my options at the Dispute Resolution Center. And so the common situation I get is over the pro se, but I live it on the other side. And so I asked the pro se if they talk to a lawyer, and often they have, but they said I just can't afford it. And so what I will do, though, besides what you've already mentioned about referring them to the law, whatever, once the other lawyer says this is the law, I'll back and I'll say, John, the other lawyer is saying that on this point, this is the law. Have you considered that? Have you talked about it? Do you want to look at it? That type of thing. But I'm using the other lawyer to give him the information, and then I'll say, now, you sure, if you don't know if he's right or wrong, you sure you want to proceed? And then try to get them to, make a decision with that in that regard. So,
thanks, Bob.
Yes.
Elaine?
We do a couple of things. First of all, in addition to having the family law code, we keep the family law toolkit book from the family law section because it's short, it's easy for them to see.
This one?
Yes.
Yeah. High tech here, guys. There it is.
Yeah. And then we have Texas Law Help. We've taken some of the most common questions and we print those out. We have a reference notebook in each room that they can look through and see. And then the third thing that we do that's a little different in Montgomery County is we have a reference attorney at the law library next to us. And so if there's an imbalance of power or there's some kind of question where they're disagreeing, we say, we can't tell you what the law is, but the reference attorney, we can call her in if you would like to ask general questions about what the law in Texas is. She can't give them legal advice either, but she can say, this is how most of the judges handle it in Montgomery County, handle an issue like that. This is what they're going to look for. Or she could say, generally, the law is this. So we do those things.
So, Elaine, that's excellent. Was someone going to add something? Because
I was just going to say Travis County has the same thing. They have a Travis County Law Library, and they have a reference attorneys. Actually, they have more than one. And so if the parties still want to go forward, but one of them is not sure that they're agreeing to the correct thing, then I would say, before you file this with the court, take it to the reference attorney or get a consultation with a family law attorney before you decide that it should be filed with a court. That would be my suggestion.
So I don't. So thank you, Belinda. I appreciate that. And two things that are coming up on the chat. One is that what did I stick up? And I think Nancy answered it. I know Nancy answered it, but it's the Texas law family law section, State Bar of Texas toolkit. These are, you can, and I think I have in my slides a link to it. And if not, if you look at the State Bar of Texas family law section, you can buy these. And for people who are lawyers, you can be in the section and you get them for free annually. They are very handy, and they have the standard possession order in them in like 2 or 3 pages versus the family code, which has it in about 10 pages. And I'm going to show you some more resources when we get along, guys, because there's a trove of information that, obviously that in our McLennan County DRC, we don't have. We have, and the person I was talking about was Catherine Logue, who's our DRC person. So if you see that person who's got the DRC who just waved, so she's an attorney, but we don't have a reference attorney nearby, and so we don't have that luxury that some of you have. And I do think that. So Sean, you asked, can we read the code for everyone and let them make their own assessment on how to proceed? Absolutely. That's not giving legal advice. That is reading out a section of code.
Thank you, John. I was just curious because I felt like that can just directly neutralize any issue. And then if they don't understand it, that's a separate issue. But sometimes, especially, and I had one more question as far as anecdotes,
Yes.
because someone had mentioned, well, we'll say this is how most judges rule, but I will speak on, at least from personal experience, helping other people mediate, and then also in my own pro se case, that felt a little bit biased when they would say how most judges ruled, especially if you're pro se going up against an attorney, because we don't know what the outcome will be once you get to court. Like you have no idea of knowing how the judges will rule. But is it fair to at least share stories of, here's what I've seen, and then again say, but we really don't know how the things will rule. Like citing the code as this is the state's default, and if you go to court, you have no idea what could actually happen.
Well, yeah, Sean, I wish you were co-presenting with me, because this would have been fun. And so, but I'm curious to hear you more in either this today or next 2 weeks from now. But I think you brought up a very good point about, and I am certainly, with lawyers in the room, I ask them usually, what does the court usually do in these types of situations? I do that all the time. And especially, for example, if I was doing one in Travis County, I would have to ask a judge. I'd have to ask a lawyer about that. But when it's the parties, I can't do that, of course. And that's a great tool. The other thing that you can think about is that you certainly can say this, which anytime you go to court, there's a risk. And anytime you go to court, no one can tell you exactly what's going to happen. And what I tell people a lot when I mediate is, if I had a crystal ball and could tell you what the judge was going to do every time, guess what? I wouldn't be mediating your case right now. I'd be on a beach somewhere, right? And so the bottom line is, no one can be certain, but you can talk about trends. But it's much more risky if you don't have people who are attorneys. involved in trying to make those assessments, and I would try to stay away from that as much as possible. Whether you're an attorney or not, Elaine.
I just want to clarify, we don't, as mediators, make those kinds of statements.
Right.
That if we call in another attorney, like
Sure.
a difference attorney, she just kind of tells what she sees on the docket, that kind of thing. So it's not us making it.
Yeah, but I don't even know if that is a legal assessment, because a reporter for your local newspaper could watch and make those same type of assessments. I mean, they may have a different feel, but it is not necessarily that. And so, y'all ready to move on? That was a great discussion. I love it. I love it. I love it. I love it. This is what I was hoping we'd do, instead of y'all hearing me drone on. So I'm going to pull up my screen again and see if we can move
we have
along.
one more question from
Yes, ma'am.
Erica asked, if clients are in mediation, would you mention that one of the nice things about mediation is you have more flexibility on the outcome than what a judge would rule, as opposed to getting caught up in the laws?
Well, I don't know exactly what the judge would do. And that's my risk, is that I can talk about trends very briefly, but I also have to say every case is different. Now, can I tell them something to that effect? Oh, I just pulled up. Whoa. And so I can tell them that, the judge will give you a half day case means not 3 hours or 4 hours. Half day means you might start at 9, you might start at 10, because the judge is going to handle all the other cases before he does a pro se case, all of them. If it's a contested pro se case, he will try to say, or the judge will try not to do those. But they'll always try to do the easy stuff first, meaning the cases that are uncontested, and then the ones that are prove ups, and then they'll do the difficult ones. And so one of the things you can also say is, this judge handles this case this way, and y'all may have a setting, but guess what? You may not be heard. And I can talk in generalities too. And I don't think that that's a violation of our obligations, which is, judges are human beings too. They hear what they hear. And if they're going to rule on your case, it may be something that they can ignore everything you say, because they don't have to take what you say is true, and they can take the other side. And when you leave that type of judgment on someone else's shoulders, you're risking not getting what you want or what you can live with. So you always go back to can you live with this type of analysis, and knowing that you have control if you try to work something out you can live with. So I usually use that as my standard. Someone asked a question, and I don't know if I answered or if anybody did, but it was, do you usually do the pro se and the pro se and the party with the attorney in the same room? I usually do not, because I think that's an inherent power disadvantage. Anybody else? I see Catherine nodding her head. Does anybody else do it otherwise or differently?
I would just,
Sean? Yes.
I can only speak from now this one on my personal case. I kept requesting for us to do it, and I could see how in most cases you wouldn't want to, but it was a disadvantage. But I do feel in this case, it could have led to quicker resolution. So sometimes, because it ended up going through then several rounds of mediation, because the attorney was attorneying on the other side. In the meantime, the pro se party, because they usually can't afford it, wants to find a resolution. So it depends, but it might be something to consider. But I can understand completely if the pro se party isn't legally savvy or doesn't talk back or represent themselves, that I would stay away from it. But sometimes it might actually lead to resolution.
All right. And I hear that. And I think it has to be, as a mediator, you do it on a case by case basis, because there are some lawyers who will steamroll everybody. And they will just make it their own. And there's some lawyers who really try to be open and have an open dialogue. And so if you're mediating that kind of case, one, you probably need to figure out if you know who the attorney is on the represented side, whether that person is a mediator. Because most people who are attorneys who really mediate a lot, if they're still practicing law, they start integrating the way they talk to almost everybody. But some can be really caustic, and the caustic bullying type doesn't need to be happening with a pro se, really with anybody, but with a pro se who doesn't have another attorney who can bow up and go back. So I hear what you're saying, and I think that you play at each of the cases and maybe there's not I don't think I've ever done one where I've put the pro se with the other attorney, but I now see that that's probably something that I made an assumption it's not necessarily warranted in every case. So thank you for that, Sean. All right. So we were on Rule 11, professional advice. And then I'm going to go to Rule 13, which is termination of the mediation session. So we should postpone, recess, or terminate the mediation process if it is apparent the case is inappropriate for mediation or one or more parties is unwilling or unable to participate meaningfully in the process. Well, that makes a lot of sense, right? But when you go to mediator school, they want you, one of your goals is try to facilitate towards a settlement and try to get people to have some sort of resolution. But if it is obvious that there's a power, someone cannot understand these concepts, should they be mediating this case? No. Should you be mediating the case? No. So it is really somewhat, I think, clear, but that is something we have as an obligation. So those 4 rules are really instructive as our foundation. So if you're at the point of going, should I be doing this? Think about those 4 rules, because that's your foundation to how you proceed. Now, we've asked some of these things, but there's, we've got the is this fair question. So, is this fair? How, Sharon, would you answer that? And I want to say hi, Sharon. I haven't seen you in a while. You can do it.
Okay, you can hear me now.
Yes, ma'am.
We always say there's nothing that's fair, right? We always start the mediation, Jane and I, talking about fair and truth, because each person has their own feelings and thoughts on what is fair and what is truth. There are many truths in every room. So that's basically how we respond. We say it a lot.
And so anybody else have anything to add to that? I love that answer, Sharon. Anybody else? I liked it. There's a lot of us wearing glasses here, and I like to say everybody, and it's the same answer, but we see things through our own lenses. What we might think is true in our room is totally different in another room. It's perspective.
Exactly.
And so that is certainly the question. But I'm curious to see, just by a raise of hands, if that's possible, or thumbs or whatever, how many people are asked that, like for every 10 mediations. Does that happen in one of every 10 mediations? It happens on a lot of mediations for me. No? Yes? Okay. Clay says yes. All right. And then there's a flying thumb. All right. Fantastic. So Sharon gave us the answer. So thank you, Sharon. And that's it. And so that is it. Evan, you would like to add something?
Well, yeah, just I appreciate the nothing is fair. And I guess what I might add on to that is, y'all get, kind of going back to your previous point, it's like y'all get to decide what you can live with, and just kind of reinforce that against the fairness.
Yeah, if you can live with it, that's really the bottom line. It's not, it is certainly what you can live with. And, it's, what is it? The Rolling Stone, get what you want. You can't always get what you want, but you can always get what you can What is the song? Somebody help me. There's somebody who knows that Rolling
What
Stone
you
song.
need. But if you
That's what
try
need.
sometimes, you just might find you get what you need.
There you go.
Yeah,
Thanks, Diane.
Diane.
Yay. If I had a prize, I'd be throwing it to you right now. All right, Bruce, you wanted to add something?
If somebody asked me, do you think this settlement is fair compared to if we went to court? I said, the court system is a process for making a decision. Whether that decision is fair, ethical, just, accurate is beyond the scope of today's discussions. However, in mediation, you're in control of the outcome if you voluntarily agree to it. If you don't, you're turning the outcome into the hands of somebody else that doesn't know you, who will make a quick decision that affects your life. It's up to you. What do you want to do?
Very nice. Thank you for that. There's all this chat in the, and before I'm seeing all this chat, so it's great. There's a lot of things talking about spreadsheets. And Nancy, I see that you're kind of talking about spreadsheets. Do you want to share with everybody what the discussion is? Where are you, Nancy? Can't see you. I can see you're chatting, but I can't see. Where is Nancy? Nancy. Where is Nancy? Huh. I see that she's been chatting. So in the chat, there's a discussion about doing homework with, Bruce was talking to Nancy about splitting things so that the parties may be put together things on a spreadsheet with assets and debts. And there's a question that Bruce asked about, do you give him a template spreadsheet? And Nancy says template. So, and so I'd like to talk about that for a minute, because I think that's an because if we're talking about money, there are certainly people who understand money better than others. And there's certainly people who understand how to handle a spreadsheet better than others. And so I'm curious about the folks who are here about how they handle, something that's not maybe an uber complex case, but maybe complex enough to where you've got retirements, a house, a car, some debt, some credit card debt. How do y'all handle that? And how do you help facilitate that understanding? So if both sides are looking at splitting things in a 50-50 way, how do you address that? Okay. And so I will start, and then what I do. So if I'm at my office, I have a big TV screen, not in this office, but in my conference room, I will put a big screen with a actual Excel spreadsheet that I have. And I'm happy if y'all want to see it, I can share it, but it's got formulas in it. But, and I can't share it right now, but I will remember to do that next time. And so I'll write myself a note right now, but I share it on the screen, and then I have people start giving me information. And we fill in the home at 9512 Cooper's Crossing is valued at this. Do we agree on that? Y'all agree on that? What's the debt on it? Someone usually has the debt amount. Then we have the net value, and then we say what are we going to do with that? And if someone wants to live in that house and they both agree, we put that in. Let's just say the wife's column. And so then we go to the next asset, which is maybe retirement. And and we talk about retirements and 401ks, and we just keep populating that. And so we know the net estate, we know what husband's getting, what wife's getting. And if it's a 50-50, I have a calculator that says it's what percentage it is, so people can play with money. Now, there are some challenges with that because, of course, a protected IRA, an IRA that for people who are in their 40s is really not going to do a lot of money, a lot of good things for people, and it has some consequences if you take it out. Selling a home certainly has some consequences because the value of the home may be $400,000 net, but if you sell it, you're probably going to pay a realtor 8%. So, but those are things for the parties to determine if they want to talk to a financial advisor about the taxable values of that. Because guess what? John Palmer, or Erica, we can't put those values. We can't give that advice. I don't want to give tax advice, and I'd be dangerous in doing that. But those are things that I do is I put it all on one page so people can see it, but it keeps adding numbers at the end. And if they're comfortable with doing that, then they can have it. They can take it home, or we use that as part of decision making. That's the way I use the template, but I have it up there, and I understand that if I've got a debt, it's automatically going to change the number at the end. So I also know if it equals 100%. But I think those are very useful tools, whether they're people who are pro se or have lawyers, because a lot of lawyers don't do that as well as have a template or something like that. So that's the way I do it. And some people will do old school who can do math in their head, and they'll write it out in columns on a sheet of paper. Just depends on how difficult and how intricate the estate is. So that's how I handle that. And so then the next question that Sean has is really the secrets and lies. How do you deal with secrets and lies when negotiating business contracts, especially in contested industries? Sometimes people can come to a mediator specifically to avoid a judge as business entities. So Sean, do you want to explain that a little bit more?
Yes. Well, and it could apply to family law as well. Sometimes parties will hide that they have a secret retirement account. They're for family law. And then on the other one, as far as like business wise, sometimes people will come to a mediator because they know it's the best. I work in cannabis and psychedelics on the legal side, but when they are in legal gray areas because of it's not federally rescheduled but legal statewide, they want to avoid being in front of a judge because it just increases scrutiny no matter what. It can create a lot of other problems. So how do you handle making sure everyone's coming to the table transparently when they're specifically coming to you because they don't want to go to a judge because there's some gray area?
Well, that's a great question. Anybody? We have about 3 minutes left, y'all. So I'd like to see if anyone has a response to that. Because my thoughts on secrets and lies are something to the effect of, and I'm going to answer this a little bit more generically, Sean, than your specific question, but I usually, or a party usually says, I think there's something else. And if someone says, no, there's not, and someone keeps saying there, yes, there is, I can try to assuage the person who thinks someone's lying by saying, okay, can we get this settled? And you think there's something else? Is there something you can think of to where, if this person is not being straightforward, how could we handle that asset if it comes forth? And then you could say that both parties agree that this is all the assets. And if there's not, if there's hidden assets, they will be handled by a further court order, which basically is the way it would happen anyhow in a divorce case. But you could try to use it in the questioning of ma'am or sir, what would make you feel more comfortable agreeing to this? I know you think there's something else out there. How can we get this to where there is a provision that takes care of your concerns if there is one? And then of course someone wrote, which is, do you want to use some more discovery? Do you need to take a break and try to find this out on your own? Because that's the safest way to do it, right? So that's another way to look at it. All right, we are probably at a good point to stop. Next time, what I think we will do is we're going to go over the resources. And if you start looking at the PowerPoints, now, do they all have the PowerPoints, Linda? I don't know. Do they have the PowerPoint?
No, they don't have it yet.
Oh, well, okay. Well, I'm going to just give you a preview of next time. So let me do that for you real quick, because a lot of the things we started talking about are also here. So down here is how not to give legal advice, and then the pro se acknowledgement form, and then all these resources here. Y'all can see all of that, right? And
Yes.
so I've got the hyperlinks and everything. And then I've got gripes about mediators, and then I've got then I've got some stuff about MSAs and binding MSAs, and also some case law. But one of the big things that we're going to be doing next time is really digging down into resources. We've talked about a lot of them today, but I really want to show you how they can be worked in your mediation. And I don't know what your feelings are, Linda, and the group, about sharing the PowerPoint early, but we can talk about that after the meeting and figure out what works for everybody. I appreciate everybody's time today and your great comments, and the participation. If you would have told me we would have had this many people today, I would have said I would have lost a lot of money. And so it's just great to see y'all's wonderful smiling faces.